Okay, we're almost there.
All right, it does say it's streaming.
Yes,
Does that record as well?
yes.
Okay, then I'll go ahead and, whoa, drop my pen. Okay, let me call us to order, so. And good morning, I'm gonna go ahead and call this session of the City of Arlington Hearing Examiner to order. For the record, today is October 29th at approximately 10 a.m. We have one item on the agenda today. This is numbers PLN number 633 and PLN 634 related to the request for approval of a binding site plan, unit lot subdivision, and conditional use permit for development of up to 500 multifamily residential units, 16 live work units, recreational facilities, on-site amenities, service parking, and associated improvements on a 20.38 acre property at 16612 51st Avenue Northeast. We're here on a remand after a appeal under the State's Land Use Petition Act. And so we have very specific limited reasons to be here. But for the record, I am Andrew Reeves. I'm a hearing examiner with Sound Law Center, who the city has selected to hold these hearings. And today it will be my role to collect evidence in the form of exhibits and testimony to address this particular remand. So I don't believe we have any members of the public at large here. We'll check in on that in a minute. If there are members of the public, I would allow testimony on the very limited issue related to the scope of the remand. I can't imagine there'd be much public testimony on that limited issue. But other than that, we just have the parties who have agreed to a stipulation. And so at this point, I'm going to turn it over to Mr. Sitkin on behalf of the city, I believe, who's going to explain the background here. Mr. Sitkin, thanks for being here.
Thank you, Mr. Examiner. Just for clarity, I represent the applicant. Mr. Weifel represents the city of Arlington. Mr. Ergetson represents the city of Marysville. And during the process of the appeal by the city of Marysville, we examined the record, and it was one of the issues that arose was a traffic report that had been submitted on the SEPA comment. It was not clear that it was before you in your materials that you had to review. So we all worked on a stipulation for a remand to have this matter come back to you for that basis. And in that process and discussions, we all reached a settlement in a sense of the city of Marysville's questions and concerns. We prepared what we hope would be efficient for you is a stipulation that would modify the decision by an order to reference the additional exhibits that would be included. We included the traffic impact analysis that was an exhibit A to their initial comments on the SEPA. Then the stipulation and order remand on the LUPA appeal would be a new exhibit 54. And then this stipulation for your record as well. We propose some additional supplemental findings of fact that we stipulate to that refer to a condition to be included as a final fact. Finding of fact that would be ultimately included as a conclusion of law and then as a condition to the final approval that is based upon this settlement. And so we included language for both the supplemental conclusion, supplemental finding of fact, and supplemental condition. And that's in the stipulation that we present to you. And that mitigation fee that you'll see that's stipulated to is implemented pursuant to the RCW requirements. I don't think that there's anything more to add that's not in the order. We just ask you to enter the order as stipulated to and presented. I don't see any other public here to comment on this, so I don't believe there's any objections to the entry of the order as written.
Okay, so to be clear, when my final decision was first produced, there were 52 exhibits that were identified. So then at this point, that additional traffic impact analysis by Gibson Traffic Consultants would become exhibit 53. The stipulated order of remand from, I believe, maybe September 14th would be exhibit 54. And then the stipulation and order would be 55. Is that accurate?
I believe it is. I had the date as September 3rd for the stipulated order, but I think the final date on that might be a little immaterial, but It was Exhibit B to this order that I submit, the proposed stipulation you have here. I'm scrolling through real quick.
It was signed September 3rd by the parties, and the order was issued by the judge there on the 14th. So
I have no objection if you want to interlineate that correction in this stipulation.
that was just what I saw right away. I don't have feel there's any need or reason for me to change anything if the parties aren't requesting it. So then ultimately, I guess my only question is, do the parties then want me to produce an actual revised order or revised decision that includes all of this, or just leave it as is, the stipulation?
I think this can be left as is. From our perspective, it was intended this order would be that supplemental decision. I don't have the need to issue a new decision.
Okay, good. I think that actually will make more sense if this ever had additional appeals or anything to that effect, because I do believe there might be some language in the decision that would contradict or confuse those that don't know the entire background. So by leaving it separate, I think it'll be very clear as to what happened. So that's fine with me. I'm gonna just do a round robin real quick. Mr. Peifel, did that all track with you?
Yes, Your Honor, that's consistent with our discussions, and we believe the entry of the order to be appropriate.
Okay, and Mr. Eggerson, on behalf of the city of Marysville.
I concur with what the other two parties have said, Mr. Examiner.
Okay, then just checking. The only other question I believe I had was, and perhaps community and economic development can ask this, but how notice of today's proceeding was provided. Just to be clear, I mean, I know it's a strange procedural matter and how we got here, but at least in my mind, theoretically, we could have had public participation, or do the parties disagree with that?
So
I think you could have had public participation. My understanding, we checked on this. Notice did go out. The city staff can confer with that. We actually have our engineer on hold at 11 a.m. in case something came up. We don't expect it, but we can hear from the city of Burlington.
Yeah, so I emailed the notice of hearing.
Hold on one sec. Is this for the audio? Is this Josh?
Yes, this is Josh Brown for the land use plan.
And I'll swear you in. Do you swear for him to tell the truth in any testimony you give here today?
I do.
Thank you. Please introduce yourself for the record, and if you can just explain that for me, that'd be perfect.
Yes, I'm Josh Brown, City land use planner with the city of Arlington. I did proceed to email the notice of public hearing to the parties of record, as well as we posted the notice on our city website, as well as we notified through our normal notice boards and issued notice through the Everett Herald, our party newspaper of record.
Excellent. Okay. So hearing that, then I certainly have no issues. Reasonable notice was provided. So my intent then is to just sign the stipulation in order. I'll sign that and get a copy back to the parties. Let's see, it's in PDF format, and I don't have a scanner, but I'll be at my office this weekend. So I'll make sure that all the parties have it here in the next, at least by Monday. So we'll make sure that gets sent out to everyone. Did anyone have anything further they wanted to add before we conclude the hearing today? I'm getting the shakes of the head. Okay, that's excellent. So thank you. Thank you for making this one of the more efficient hearings I've had in a long time. I think the parties have managed to take care of everything, which is great. And as I stated, I'll go ahead and sign this order, and this will take care of this matter. So good luck to everyone, and I hope everyone stays healthy. And with that, we can go ahead and end today's hearing. Thank you.